Coming on to the offence of wrongful confinement. Offence of wrongful confinement is similar to the offence of wrongful restraint to the extent both the offences curtails the free movement of a person. But there is a difference between the two offences. Where the offence of wrongful restraint obstructs the right of a person to go in a specific direction of his choice, the offence of wrongful confinement confines a person within certain boundaries. Have you seen Dangal movie, where Amir Khan is wrongfully closed inside a room to prevent him from watching his daughter's wrestling match? That is wrongful confinement. In fact, all those Bollywood movies that show father locking up his daughter in a room so that she cannot meet her lover is actually wrongful confinement. The offence of wrongful confinement is defined under section 340. According to this section, whoever wrongfully restrains any person in such a manner as to prevent that person from proceeding beyond certain circumscribing limits is said to wrongfully confine that person. Here, circumscribing limit means boundaries of a place. So basically, this section says if a person wrongfully limits another person within the boundaries of a specific place, it will amount to wrongful confinement. For example, if Mr. X locks up Mr. Y in a room against his will and consent, it will amount to wrongful confinement because Mr. Y is confined within the boundaries of that room. Similarly, a person can be confined in a building, in a car, in a hotel, or even within a city. Again, as mentioned in wrongful restraint before, in wrongful confinement also, it is not necessary that person must be restrained physically. It is enough if an impression is created in the mind of the victim to cause a reasonable apprehension that he is not allowed to move out of the confined area, and if any attempt is made to do so, then he will be restrained. For example, Mr. A wrongfully confines Mr. B in a room. The room does not have the lock and bolt. Mr. A wants Mr. B not to go out of the room, otherwise it will not be good for him. Now Mr. A goes out for some time, leaving Mr. B alone in the room. Remember, the room does not have the lock and bolt, and Mr. B could have easily escaped. But Mr. B does not make an attempt to escape because he was fearful of the threat given by Mr. A. So here Mr. A will be guilty of wrongful confinement along with the other sections of IPC. Mr. A cannot take the defense that Mr. B was free to escape when he had gone out, as there was no lock and bolt in the door, because Mr. B did not escape because of the fear of threat given by Mr. A. Coming on to the punishment of wrongful confinement. Punishment for this offence is prescribed under section 342. This offence is punishable with the imprisonment extending up to 1 year or fine of 1,000 rupees or both. Offence is cognizable, bailable, triable by magistrate, and compoundable by the person confined.